What we're going to do then, because what do they call these? Technical difficulties. I am having, Linda Conaway came over to my house last night. We tried to play with it. We probably made it worse. So I bought a new computer. But of course, for those of you that know me, you know that I have absolutely no chance of setting it up myself. So I got to wait for one of my 8-year-old grandchildren to come over and they'll figure it out. So I'm going to get started. Cody, you can jump in. I'm not sure if I'm going to be able to hear you or not. So we'll just do the best we can. I'm going to try calling in on the number that Cody gave me and see if that works. But in the meantime, here's what we're going to do today, kids. The legislature was incredibly busy this last go-around. They introduced 5,426 new bills. Fortunately, at some juncture, they decided, at least in theory, that they were only going to deal with the COVID-related legislation. And so they passed a number of bills. We're not going to talk about them all today because some of them are business-related, dealing with things like expanded leave. There are some workers' compensation rules that are going to go into effect, but we'll have time between now and the end of the year to get you up to date. However, there is a new piece of legislation, the COVID Tenant Relief Act of 2020, Assembly Bill 3088. It's a 36-page bill, small print. Cody and I have had a grand time over the last week trying to dig into it. We both took a pretty deep dive, and we're going to spend a good half hour walking you through some aspects of that bill. You're going to ask questions. Hopefully you'll put them in the box because I can't hear you. And then we'll figure out how to get those questions to me. In the meantime, we also want to talk about a couple of other things. About a week or so ago, I was fortunate enough to do a fair housing program with a couple of really phenomenal attorneys. One is Brandon Butler. Brandon's an attorney for the Department of Fair Housing and Employment. Brandon has been very instrumental in writing a bunch of the legislation and in doing a lot of the training, and we talked about realtors and fair housing. Also joining that meeting was Brian Green, who is the attorney and now works for NAR, dealing with issues of fair housing, inclusion, and those kinds of issues. And I was also blessed a couple of weeks ago to do a program with the Department of Real Estate's new commissioner, pretty impressive guy. Scared us a while because he doesn't have a major background in real estate, but I got to be honest, I was impressed. We tried something a little bit different. We were able to send him 10 questions. He agreed to answer 6 of them, and so we did sort of a press conference kind of a program where he answered questions, I would comment, we went back and forth. So I'm going to go over the 6 answers to the 6 questions as part of today's program. In that regard, we're going to talk a little bit about risk management. I see here that John Messina, who's probably one of the finest attorneys in the Valley, is on the program with Cody and I. And so John, when we get to that section, unmute yourself. I know you got a much better setup than I do. And we'll talk a little bit about what's going on in the world of risk management. Then if we have time, and I'm not saying we will, we're going to talk a little about some stuff that's going on with cyber fraud and advertising and social media issues. But we'll try to wrap a lot of that into the fair housing conversation and into the liability question. I did have an opportunity to talk to 2 incredibly fine professional standards managers. One is yours, Linda Conaway, and the other is Lori Smith, who works for another association. And between them, they do professional standards for well over 20,000 realtors. And they gave me a list of the kinds of calls that professional standards is getting, where either members of the public or you guys are complaining about each other and or about organized real estate. So we'll go through that, and then of course if there's any questions about clear cooperation and all of the rest of that, we'll do what we can to answer. Want to get done with this in about an hour, and then we're going to muddle through, and I mean truly muddle today, and I really am sorry about how this is working out. But we're going to muddle through the question and answer session. Cody will figure that out when we get to it, and that's what we'll do. So I'm doing a program on Thursday with a guy named Carlo Bacchi, and Carlo handles the investigation side of the Department of Real Estate, and he told me in preparation for our program on Thursday that he has currently 43 COVID-related landlord-tenant revocation hearing investigations going on just in his office alone. So clearly, being a property manager today is not a lot of fun. So what happened is this, is back in March, actually late February, early March, the governor started issuing emergency orders. One of those orders clearly was to basically shut down collection of rent for an untold period of time. There were no indications of who was qualified or who wasn't qualified. Simply, they said there's a blanket moratorium on rent, and there's also, through the Judicial Council, we're going to close down the courts to unlawful detainers for the most part. And of course, if you remember your PPP loans, they were for 8 weeks. Why? Because nobody thought this was going to last 6 months. Well, we're now 6 months into this, and of course, you now have rent that is due from March 1st to August 31st, and of course, now from September 1st on, you also have rent becoming due. And so the legislature was faced with a very real problem in talking to Fair Housing, Brandon particularly. They were deeply concerned about the tens of thousands of people who might have been made homeless if landlords were suddenly allowed to helter-skelter do evictions. On the other hand, what about the poor landlord that still needs to make all of their payments and all of the rest of that? So the legislature, in its wisdom, passed Assembly Bill 3088, which is commonly referred to as the Tenant Relief Act of 2020. It's actually much broader than that because it covers some homeowner rights, and it covers some forbearance issues on mortgages and so forth. It's 36 pages of wonderful small print. It is got a lot of overlap to it regarding both this law and Assembly Bill 1482, which is the rent control law that went into effect on January the 1st. So what this bill did was to preempt some of that legislation, but not all of it. And so it supposedly provides protections for both tenants and some landlords. Now let me get rid of the landlord issue first. If you're a landlord or your client is a landlord with 4 or less units and is not a corporation, a real estate investment trust, and or is a LLC that does not have any corporate partners in it, then you are qualifying as a small landlord, and there are going to be some protections for you, but they're minimal. Most of the protections deal with forbearance on mortgages and things of that nature, which, if we have time, we'll cover later. There are going to be 12 new or revised forms. I have a list of them here, and you need to be very aware of those forms because these forms are either new or will replace the forms you're currently using. For example, there is no longer, at least in the context of rents that have become due between March 1st and January 31st of 2021, if rents become due during those period of times, the 3-day notice will now be a 15-day notice, and it, again, does not include weekends and holidays, so basically the 5 work days absent any holidays that might occur. So you have a much different rule, and inside those notices are going to be requirements that you provide certain information and or other notices to your prospective or current tenant. Secondly, if you're claiming rent that has come due between March 1st and August 31st, There's going to be a notice that you must provide generally by September the 30th of this month, so next week. And if you do that, then you'll be allowed to take certain action. So what kind of forms are we looking at so that you're aware? Well, there's going to be a form that is basically a tenant declaration for those tenants that have rent come due between March 1st and August 31st. Inside that declaration and the accompanying notice, which is also a form, will be all of the reasons why the tenant did not pay rent. And there are 6 COVID-related reasons why the tenant will not have to pay rent during that period of time. And separately, I want you to listen to this, because there's 2 separate notices. If you don't get rent from any time between March 1st and January 31st, then you have to give, and you want to get paid back in some fashion, you have to give 2 notices. One for the rent that became due through March 1st to August 31st, and then any rent that became due from September 1st to January 31st of 2021. Now, here's the deal with the rent that comes due. First of all, if it's rent that was due between March 1st and August 31st, if that's the rent that became due, and the tenant provides you with the declaration that says it's COVID related, that what they essentially have done, and Cody, disagree with me if you will, or tell me if anything you want to add to it, but what they have essentially done is said that unpaid rent is no longer grounds for an unlawful detainer. So I want you to understand that. Essentially, I have not paid my rent for any period of time, either entirely or in part. If that's the case, and I get this declaration from my landlord, my property manager, whoever, and I fill it out and I send it back, number one, you can't question it. I don't have to provide you any proof whatsoever unless I meet a threshold called a high earner, which I'll talk about in a second. So if I'm making less than $100,000 a year, I'm pretty much free and clear. I'm telling you that I'm not paying because I had increased child support, I lost some hours, I've lost my job, all of the reasons that are contained in the notice. If that's the case, then pretty much you're done in terms of evicting that person for unpaid rent. If it happens between September the 1st and January 31st, the tenant will be required, assuming they can meet the threshold under the declaration, to pay 25% of the rent that comes due. However, isn't this fun? So what they're going to be required to do is they have to pay 25% of the rent. So let's say, John, I'm renting from you and it's $2,000 a month. I have to pay you $500 a month, but I don't have to pay that until January 31st. So you don't know today, if I say I didn't pay any portion of my September 1st rent, and you follow the rules and do all the things you're supposed to do, you still can't evict me because you got to wait till January 31st, and then they'll set up a process for you to collect the amount that wasn't paid. So what is going to be the process? Well, what they're doing is they're changing the jurisdiction in small claims court. Right now, for most people, the jurisdiction amount in small claims court is $10,000, but there's restrictions on that as well for certain people that file multiple claims, all the rest of that. Those rules, as far as unpaid rent, are being suspended through February 1st, 2025. So 4.5 years, roughly 4 years, when this thing finally hits the road. So as of March 1st of next year, instead of filing an unlawful detainer with a 3-day notice to pay rent or quit, what you're going to do is you're going to sue me in small claims court for any amount whatsoever. Couple of things on that. Personal observation, my opinion, not Terry's, not Connie's, not the board's. My personal opinion is there's some real problems with that. Number one, attorneys are still not allowed, as far as I can tell in the bill, to go into small claims court. So if you've got a large amount of money that's owed to you and you're going in without an attorney, you may want to think twice, particularly if there are other issues, because there's a broad section of retaliation claims and retaliation defenses. So that's number one. Number two, what are you going to get if you get a judgment? So I go after, John comes after me, he gets a judgment for whatever the amount is. If it's $2,000 a month between March and August, and then plus the rest of the rent between September and January, he's going to get a judgment. Now, this is where it becomes a case-by-case analysis for those of you that collect this money. So you end up, Deborah, I know you do property management. I can see some of you, not all of you. So you get a judgment against your tenant for $20,000, right? It's no different, and of course the tenant has the right to appeal to the Superior Court in a de novo kind of trial where attorneys are allowed and all of those kinds of things. But let's say you get a final judgment and it's $20,000. You collect it against me in the typical manner that a lawyer or anyone else would collect a judgment, right? Well, a primary asset is what? A home. Well, this person doesn't own a home, they're renting, right? And so unless they have a home somewhere else or other real estate, that's an asset you can't go after. So primarily, what are you going to go after? You're going to go after their income. Well, if I'm a single mom that's working on a relatively small salary, or maybe I'm getting child support, I'm going to file a claim for exemption. And we're going to get down to a relatively small amount. And of course, you're going to get anywhere between 25 to 50% of that amount, depending upon how your judgment is worded and what the exemptions look like and what the court orders. And you're going to be collecting that money over a long period of time. Also, and John has an excellent bankruptcy attorney in his law firm, I'm guessing, and I don't do bankruptcies, but I'm guessing with all the debt that's being piled on, you're going to see a lot of people either file Chapter 7s or Chapter 13s and say, you can't collect this money because the bankruptcy court is either going to discharge the debt or you're going to be put on a 5-year repayment program in terms of how you get paid back. So, in terms of rent collection, you've got to be really, really cautious about thinking about each particular tenant, because each particular tenant, frankly, is going to be a different story. Some tenants are not judgment-proof, frankly. They're capable of responding because of assets they have. And of course, you know that because you took an application, so you're going to have to analyze all that. If it's a tenant that is barely making ends meet, which is really what this law was intended to try and protect, although they didn't create any exceptions, then you're going to have to figure out, what are your chances of collection, because your other option, and there's a form going to be prepared for this, comes out on September the 30th. It's a form that will allow you to basically, it's almost like a cash for keys kind of a form, right? And you're going to be able to work out some type of a forbearance, some type of an agreement that says if the tenant doesn't comply, then you get the property back. And so you're going to need to read that form very carefully. What Cody and I will do is once all of the forms are out, sometime late next week or early the following week, we'll do a quick analysis and put it in, and Connie, you can post it on the website for everybody, and of course NAR or CAR will do a great job as well. So again, there's going to be 2 notices and 2 declarations. You got to make sure you understand that. So if you're claiming rent for both periods, then you got to send out both notices and both declarations. There's also a notice that should be due by September the 30th that should go to all of the tenants that you have who owe rent between March 1st and August 31st. And it's form NTRA, NTRA. And it's simply an advisory of the tenant's rights. If you don't send that notice by September the 30th, then before you can send any other notice, you're going to have to send that form. So for those of you that have that form, it's available now. Go to SRCAR, it's NRTA. You fill out that form and get it to all of your tenants, and that's one less thing you'll have to worry about. So, also, and this does not apply for us, fortunately, and when we do this program in other places, we've got to worry about what? Local moratoriums, right? So if you do rent property management, or you have property in areas other than this wonderful conservative area, you're going to have to be thinking about that jurisdiction, because as of the last time I talked to SRCAR attorneys, there are 141 different moratoria in place. Now, this new law does preempt some of that, but not all of it, and it's very, very complicated. So for those of us here in Temecula, Murrieta, Canyon Lake, basically Southwest Riverside County, you're in good shape. You don't have anything like that I am aware of. On the other hand, if you're in an area that has one of these rules, then you better be prepared. So, again, that's an advisory notice, and you know my mantra: before you send it to anybody, read it. Take the time and read it yourselves so that you understand in case your tenant has questions, right? Because the law makes it very clear, and Cody, I know you've been doing a pretty deep dive into this one, but the law is very clear that tenants who violate any aspect of this rule are going to be susceptible to some pretty hefty fines. I know that, Sandy, you asked us a question, and we're going to answer it later, about trying to get a tenant out on a sale. And here's the deal with the fines, children. If you violate one of these rules, number one, the least that's going to happen to you is everything you do relative to filing a lawsuit, giving notices, all of it. If you violate any of the notice provisions, it all is for naught. Everything that you do after failing to properly serve the notice is void. Okay? So you got to serve the notice correctly. That's why you want to read this stuff when the time is right. What's interesting is that the tenant doesn't have to do a thing. The tenant doesn't have to provide you any proof that his declaration is true, unless he's a high earner, and then you're not allowed to ask for proof. You're supposed to have that proof on file already. So Robin, if you have a client that has, I feel like I'm almost in the room. It's kind of cool with the gallery. But if you have a client that is what's called a high earner, which is somebody that's 130% above the median in the county where they live, but they have to make at least $100,000. So I think the cutoff was like $77,000. Anybody that is in the 77,000 or less range is not going to be a high earner pretty much in any county. But if you're in Marin County, where the median income is, certainly enough to be able to afford a nice haircut in a salon visit, then you're going to be looking at a much higher median income, and most of those tenants are going to fall into the high income bracket or high earner bracket, and then you're allowed to challenge their declaration if you have information that you took when they first rented that indicates that they are a high earner. So, a couple of other things that it's pretty clear to me, Cody, that this law is super hyper pro tenant. Okay, I don't think there's any question about that. I mean, when you look at it, basically, the landlord is punished from anything from having all of your procedures declared void to a $200 a day fine to as much as a $2,000 a day fine for those people that are really, really naughty. Okay? People that misuse the rules. So that's number one. Number two, the tenant cannot waive any provision in this law. All of the rights that have been given to the tenants are non-waivable, kind of like your TDS in a standard transaction is non-waivable. All of the laws that we're talking about today are non-waivable. They changed a couple of other things that were very important. As you know, under 1482, which was the rent control law that went into effect, you've got two separate categories. You've got for cause evictions, and you've got no fault, just cause, or no fault evictions, right? All of those remain in effect except for a couple. Number one, rent, right? Rent is no longer considered, at least from March 1st to January 31st of 2021, is no longer grounds for eviction. Number two, the situation where you're going to try and remove the tenant in order to upgrade the property has now been deleted from the new law. Cody made a great point this morning when we were talking about this, that it seems like we knew going in that they were going to whittle away at any landlord benefits when they first passed the law on January 1st. That was a given, right? You look at San Francisco rent control, you look at LA rent control, that's where this was all going to head. All this law is allowing them to do is to hopscotch over the next couple of years and to basically rescind a lot of those protections. So from now on, if you're going to ask a tenant to leave so that you can fix up the property, unless it has to do with what we call habitability, what the statute is calling tenantability, which is pretty much, as far as I can tell, the same thing. You've lost that. So a question came up: can you evict a tenant if you're going to sell the property? Sort of yes. Here's the deal. Number one, doesn't matter what type of a property is. This law does not apply to any commercial, and it does not apply to short-term, less than 30-day vacation rentals, things of that nature. So, but for anything else, condos, houses, even houses built in a relatively short period of time, this law is now applicable. So if you're going to sell the unit, first, you got to wait until you're under contract. You can't do it ahead of time. Why? Because you don't know until you go under contract whether the buyer is going to occupy the property. If the buyer is not going to occupy the property, you have no rights to evict that tenant, right? So someone asked a question. I know, Wendy, you sent over a couple of really great questions, actually. And one of the questions was, my buyer wants to get the tenant out, make the property vacant, and then raise the rent. No, you can't. Right? Because the buyer is not going to occupy the property. That is no longer grounds for eviction, right? And that was pretty much true before 3088 because of the way the law was and still is written. So you guys understand that? Number two, I want you guys to listen to this carefully, because I get a lot of calls. Cody gets a lot of calls. Probably the second most common call that we get has to do with, tenants and properties and sales and removing the tenants. So when you guys check off that box as to how long the seller is going to be allowed to remain in the property, you better think long and hard about anything over 29 days. Okay? Typically right now, there's two forms you can use. One is the seller in possession, the SIP. That's your standard, closed plus 3, closed plus 4, whatever you kids are agreeing to. That's going to be fine. That is not going to be part of this law. It is specifically exempt. But you get into some murky territory if you are going to be dealing with anything over 30 days. Okay? And so what you're going to have to do there is you're going to have to, if you're going to, let's say, for example, the seller is going to be able to remain in the property for 120 days, okay? And part of the agreement is that they will pay rent for that 120 days. And then they don't pay rent. Well, the grounds for eviction is what? Non-payment of rent. probably not going to be able to get rid of that tenant until you wait out the 120 days. So be very careful about that. There's going to be all kinds of fun things. People are going to try all sorts of cool stuff. Lawyers like Cody and John and myself will try to, do end runs around these things, and we'll figure stuff out, and it'll probably mostly not be successful. Simply because the law is very, very clear that the purpose is to protect tenants from being vacated. Now, those kinds of people are not the kind of tenants that we're talking about. So let's see what else did I want to tell you about. Again, what are the forms that are coming out? Well, there's going to be revised forms for all the notices to quit, whether it's a notice to cure and quit, whether it's a notice to pay rent or quit. All of those notices are being revised and will be much longer and more inclusive, and will have all of the things that you will need. Now, you can go to the Department of Real Estate site right now and get some of the stuff, but it's sparse. It doesn't really cover all of the things that the SRCAR forms are going to cover. So my suggestion to you is wait till next week and get the forms that SRCAR's produced. There are some there now, like the NRTA form is there now, but there's like 3 or 4 forms that are available now. But most of those forms are going to be available, according to Neil Kalin, by the 30th of the month, and then go look at them. I don't know how we're going to do this. Maybe we'll tape a tutorial, or we'll figure it out. But there's going to be that. There's going to be a rent repayment agreement that will be a calculation that you and the tenant can agree. This is what I owe. You'll do the calculation on that form. I've seen the draft. I don't know if it's available now or not. I'm not a realtor, so I didn't check. But they make it very clear on that form, as you're calculating unpaid rent, do not include late fees. In fact, my strong suggestion is do not include late fees in any of this. You'd be lucky to get your rent. But don't include late fees, because there's a lot of questioning going on in the courts and in the legislature about whether late fees will be appropriate. There's all the notices you're going to need. There's 2 declarations and 2 notices, and they're going to be available next week. All of the notices to pay rent, all of those things are going to be ready for you guys next week. So there's a couple of other things I wanted to talk about. There's so much. I don't even know where to begin. This could actually be its own 2-hour program, frankly. I know. So a couple of resources. Go to SRCAR's website. They have a whole section on all these COVID-related laws and activities. So take a look at that. I'm sure Connie has all the links that she would need to be able to go there and to take a look at that. Again, think through how you're going to handle rent collection, because under very rare circumstances, your rent collection is going to be based on the client's or the tenant's ability to pay. It's not going to be based on any other factor. Make sure you think through what kinds of reasonable accommodations you might need to make in order to work through the business aspects of this, and make sure that if you're going outside of the local area, that you are very careful in making sure that you're aware of any local jurisdictional issues, because cities and counties have their own rules. For example, LA, some of Beverly Hills, even some of those areas have their own special rules. Think about sending out the notice, which is the NRTA form, now. Again, there's not much to fill out. The one thing I've noticed about this law that you'll probably get disturbed about is there's no proportionality. In other words, let's say I'm a single mom and my child care payments have gone up $500 a month because the schools aren't open, or my preschool is not working the way it should, or whatever it might be. Okay, but my rent's $2,000 a month or $1,500 a month. It's not a dollar for dollar. In other words, if I can claim any of the 6 items in the declaration, It doesn't have to be proportional to the amount of rent. So basically, even if I'm getting EDD money, or if I'm getting other forms of money, if I have sustained any kind of loss under the 6 categories, and they're the ones we've been hearing about, child care, caring for a close family member, which has pretty much been broadly defined, all those kinds of things, I'm not going to have to pay rent. Again, remember, there's 2 periods of time involved. The declaration: loss of income, increased out-of-pocket expenses, increased expenses directly related to the health impacts, child care responsibilities, increased costs for child care responsibilities, or, quote, other circumstances related to COVID-19 and loss of income. Okay? Any public assistance, including unemployment insurance, pandemic unemployment, all of that does not fully make up for job loss. Okay? So you're going to have to deal with it. Think about how you're going to want to respond. Have good conversations that you document very carefully with your landlord clients. If you are a corporation, or you're representing a REIT or something, a real estate investment trust, remember, a lot of these protections that are in existence don't apply to you. And then, of course, if you are a small landlord, which is 4 or less units, take a look at the homeowner protection laws. If it's federal, then there are federal laws that will protect you under federal law. If you have a federally insured loan, if it's a conventional loan, then you've got to look to California law, and they've expanded the protections under the Homeowners Bill of Rights to include landlords who own less than 4 units. Okay? So let's see if there's anything else I wanted to talk to you about. Well, there's a lot of stuff I want to talk to you about. I'm sure it will come up in the question and answer session. Cody, anything? I know of the 36 pages I covered about 3. Is there anything else that you'd like to talk about?
Hear me or no?
I can't hear you, so you're going to...
So I'll just jump in briefly then to kind of add to that, if you will, while he tries to maybe fix some of those issues. Just one of the things, I'm seeing a lot of questions in the chat. I want to acknowledge I'm answering some of those as they're specific, but I'm answering them in direct messages. So we'll address some of the more broader ones here once John gets his microphone up and working. But ultimately, I just want to let you know that there are ways to, whether I'm engaging on the side. If you have a question, go ahead and put it in. I apologize, the phone caught me a little off guard. In any event, one thing I do want to touch on briefly, which I know was also in the email string, kind of the topic of this presentation was the increase in cyber fraud right now. And just by way of kind of shifting while we give John a moment to get on the phone call, I wanted to just at least address that there has been a huge uptick in ADA claims. These mills are going around looking for software on your website, code compliance. They're looking for physical properties, and we're seeing a large amount of them. I've seen over 5 in a 2-week period over the last week or so. So just be aware of that. Make sure your website's complying. Make sure that your property is complying. There's a lot of great services out there you can go to run basically a compliance check on your own properties. And then as property managers, that's something really important to talk about with your landlords as well. I think we're giving... John, can you hear me yet? Doesn't look like it. I want to address some of these questions on the side, but I want to give John a moment. So I'm going to just continue to rant for a brief second. I will note, I saw a question or two on the side. Most of these notices for the tenants need to be given for non-payment of rent by September 30th. I know I saw a question or two on the side. And I want to clarify, this doesn't have to be given if you're trying to evict them for something that's not the non-payment of rent. By way of example, I'm working on a case right now where it's it was not an arm's length lease. In short, that notice is not applicable. That's a completely different argument, and that notice does not need to be provided in that situation. So if you have questions about that, please feel free to reach out. Send us an email. We're more than happy to address those. Or if you want to put them in the side right now, I can address them based on the unique facts of that situation. John, thumbs up, thumbs down. Can you hear anything?
Just for some reason, whoops. long as I mute myself. Can you guys hear me okay?
Yep.
Say yes if you can, okay. So, a couple of things. There's a couple of questions that came in. Getting the buyer out, okay? If it's not related to rent, you then have to say, do you qualify for any of the other reasons to kick a tenant out? For example, I am going to move into the property, or my buyer is going to move into the property. Then you would file your unlawful detainer, but leave out, because what it says is that an unlawful detainer that in whole or in part is based on rent, it's a no-go. So you have to solely be able to rely on these other reasons for kicking a tenant out. So Deborah, you have a client or a tenant who is violating some local ordinance, I don't know, growing marijuana, doing whatever, or is creating a nuisance. There are, if you recall, there were 15 original categories that you could kick a tenant out. 4 just cause, and then the 11 that are no cause. And so you're down to 13 now, right? They eliminated the improving the property, and they eliminated rent. So now you can take a look at the other 13, and you ask yourself, can I kick out a tenant? One of the things that comes up all the time, and we have a question here about it, is the tenant not allowing access to the property for a legitimate purpose related to the landlord's responsibilities. That is, under the 1482 law, the one that went into effect in January, that is grounds for kicking a tenant out. You got to be really careful, however, because remember, these tenants are going to have access to legal aid, they're going to have access to their own lawyers, more than likely your rental agreement contains an attorney's fees clause, and they have a right to a jury trial. And so you better be able to prove that this had some negative impact, because again, the courts are going to look. But if it's breaking the law or something along those lines, you're going to be okay. And you probably, I think, Cody, they're going to start issuing summonses now for those kinds, and then if a tenant doesn't return the declaration within the 15 days, I think after October the 4th, you can actually have a summons issued on an unlawful detainer.
Can you hear me, John?
So, can I evict a tenant from my rental property if I want to occupy that property? Yes, but you got to go through the process, and you better not lie. Because remember, I told you there are penalties up to $2,000 a day. And so, again, be very, very careful. My client received a 90-day move-out notice to move out by November. Since the landlord decided to sell the property, they are paying rent lower than market. No rent is due, but they would not be able to afford high new rent. First of all, I got, this kind of goes to another question we got. I don't know if it's the same person. No, it's not. But here's the deal. If you're not going to be able to kick a tenant out so that you can get higher rent. You couldn't do that under the old law, right? If I'm month to month, the reason for kicking me out has to do with me wanting higher rent. You can't do it. You can still raise rent under the statute. There's nothing in the new statute, Cody, that I can recall that says you can't raise rent. But you can raise rent 5% plus inflation, which my recollection is in this area, I think it's 1.9%. I could be wrong on that. You can double check. It came out in April, and they go April to April. So you can raise rent. Whatever that figure is, around 7%, you can do that. But that's it. But to kick somebody out so you can sell the property, you can't do that. You have to, Cody, as I read this statute, you have to be under contract. Why? Because then you're going to have the RPA, the buyer's going to check, is not going to check the box that says does not intend to occupy. Because if he checks that box, that tenant becomes his tenant. If he checks off if he doesn't check off the box because it defaults to I'm going to occupy, then yeah, then at that point you can provide whatever notices there are. And I'm going to tell you, you're going to need to be talking to your lawyers about a lot of this stuff, because a lot of it is you're going to be doing a 100-yard dash through a minefield if you don't have some legal advice on some of this stuff. So, and if you're in a mobile home park, the law does apply. So you've got a whole section in the new law on mobile home parks that says all of this applies, plus all the mobile home protection laws that are already in effect. Cody, I don't know what you covered, so I want to jump into something else so we can open it up for all these questions. I want to talk about fair housing for a second. Most of you remember, or if you don't, I'm going to tell you, that Newsday, which is a magazine, some of you read, some of you don't, but they did a 2-year study in Long Island, New York. And what they did is they sent out testers, African American testers, Hispanic testers, Asian testers, and of course Caucasian testers. And they determined after the study that about 49% of the time, if you were African American, you were being discriminated against in some very serious way. If you were Hispanic, the number dropped to about 39%, still beyond the pale of understanding. And then, of course, if you were Asian, the number was a little bit lower, but not much. So this was incredibly embarrassing to NAR, as you can imagine. It was incredibly embarrassing to CAR, because everyone pretty much believes that this is going on here in California, whether it's going on to the same extent or not, but it's going on. At the same time, the Department of Fair Housing issued 50 pages of new regulations dealing with discriminatory conduct, and Cody and I have developed a friendship with this wonderful attorney by the name of Brandon Butler, and Brandon has been walking us through these 50 pages because, again, they're fraught with peril. So he said something to us a couple of weeks ago that I really took to heart. If you are handling a client, either a tenant or a purchaser or a seller, and you're treating them differently because of a characteristic related to one of the protected categories under California law, and there's 24 of them, but primarily race, ethnicity, those kinds of things, if you're treating them differently than you would treat a Caucasian person, you're probably in violation of a fair housing law. And where is this coming up today? Advertising. Be careful about your advertising. Dennis Green, who's the attorney at NAR, wasn't particularly concerned about that, but both of them, when we did our fair housing, was very concerned with what everyone is commonly referring to as the love letters, right? The letter that the buyer writes to the seller telling them why they should be chosen, because in some of those letters, apparently there is some reference, either directly or indirectly, to race. Whether it's a photograph, whether it's something else, and both Brandon and Dennis were deeply concerned about the ethical condition, or ethical requirements that you have. So a couple of things on that. Remember, there's California law, there's federal law. According to what we talked to the Department of Real Estate Commissioner about, if he gets a fair housing case, it goes to the top of the pile, and it could end up costing you your license. So be very careful of anything to do with fair housing. There's some best practices that seem to work pretty well. The decision on selecting price, neighborhood, those kinds of issues ought to be the buyers, right? If you're steering buyers into a particular area, you're opening yourself up to a claim. Secondly, real estate licensees should provide complete and objective information to everyone, regardless of their skin color or any other factor. Bottom line, you ought to have information, and that information should be the same for everybody. Number three, real estate licensees should provide the same professional courtesy. One of the issues, I know it sounds, I mean, it does to me, but you know, I'm not a person of color, and there were situations where Caucasian people were offered certain kinds of courtesies, cup of coffee, a ride, this or that were not offered to the African American community. Now, that certainly should not happen. Everyone should be, basically, you should be colorblind and you should be ethnic blind in terms of all this. In terms of the Asians, the issue was what? People traveling back and forth to China and all the stuff that's going on in the newspapers. So be careful about that. Be very careful in the statements you make and or in the advertising that you do to make sure that it's not zeroing in on some issue that is protected. Make sure you can accommodate people properly. Again, one of the things that I took very personally when I was talking to Dennis in preparation for that program. Dennis is the person who's in charge of diversity at NAR. He pointed me to a video, which I highly recommend. It's about 52 minutes. It's on the NAR site, and it has to do with the kind of bias that you really don't realize you have, right? That sort of unconscious bias that we either grew up with or because of the neighborhood we might have lived in or something along those lines. The bottom line is this, is that fair housing is no longer a back burner issue. It has reached the front of the burner. And the commissioner is extremely conscious of these types of issues. So is NAR, so is CAR. And so, again, you've got two specific code of ethics issues. One is Article 10, which says in all of your real estate practices, including employment, you won't discriminate in any manner based on the 10 categories. You then have the new standard of practice, which says you will not treat each other in that manner. So it basically protects realtors who fall in one of the protected categories. So be very, very conscious of that. And so what else do I want to talk about here? Okay, unmute yourself, John and Glenn Bionde, if you're still there, because I want to talk about liability. Okay, Cody and I have had many cases, many phone calls, and here's what's going on. Liability, that's the word you guys use. It's basically, what is my legal obligation or duty? Did I fall below some standard of care when I had to discharge that duty? Did falling below the standard of care in some manner cause the person who is claiming damages a financial or other loss? Is that foreseeable? And so we've got all sorts of cool stuff going on right now. In talking to the professional standards people, we still, and I don't understand it, I guess you like sending Cody and myself and John and Glenn on vacations, but we're still seeing situations where you're not presenting offers that come in. I understand it's a multiple offer market in many cases. I understand that there's I would assume, a desire on some of your parts to make a little bit extra money. I understand all that. But the bottom line is this. You have an obligation to present all offers objectively to your client until your client tells you they don't want to see any more offers. And that needs to be in writing and put in your file. Okay? So that if Pauline sends me an offer, I need to present it to my client as soon as possible, and then I need to confirm in writing, if asked, to the buyer's agent that I have submitted that offer, and then work out whatever arrangements need to be worked out. And for whatever reason, we're getting that call, and of course when we talked to the commissioner, and when I talked to Carlo last week, he's actually on the program we're going to do on Thursday. He's actually going to put a warning out there that if you get caught doing that, so let's say, for example, Pauline sends me an offer and I don't submit it to my client, and then we close escrow on another offer, and my client finds out that there was an offer from Pauline for more money, and her client or Pauline, and according to the DRE, should have your client file the complaint, don't you do it. They don't really care about realtor complaints. But if the client files a complaint, that becomes what? that becomes a fraud violation, right? Because you just failed to discharge your duty to your client, and and cause them serious financial harm. And it doesn't matter how much, because it's all relative. Okay, and so you need to be very, very careful about failing to do that. The other thing that we're seeing, and I gotta love you guys, I really do. There's not any of you guys that are on the phone call today. I'm sure the 200 or so of you guys are doing everything you're supposed to do, right? Sandy, I know you are, because you're smiling. Terry just put a thumb up, and I've known Terry for 20 years, and I've never known him to make a mistake. So yeah, I know Deborah just threw her head back. But the reality is that we all make mistakes. And when we talk to the commissioner, you know, I forgot to make sure that the property was wiped down, or somebody came in without a mask, and oh my God, I just, you know, it didn't happen, right? My house is for sale, some of you know, and I get people traipsing through here all the time. I would love to keep a scorecard of the people that screw up. But most of the time, it's just an inadvertent mistake, right? No harm, no foul. But what about flagrant violations where people are simply saying, you know what, screw it, I'm not going to follow the rules? Number one, people like John and Glenn are going to tell you, you just fell below the standard of care, and if there's an injury related to that conduct, you're going to be liable. Number two, the commissioner made it very clear that while he's at worst going to issue a citation for some kind of a violation, if it's consistent, if it's flagrant, if it's basically stubbing your nose at the people that are making the rules, whether you like the rules or not, we can argue all day long about whether these rules make sense. Most of us believe most of them don't. But that's not the issue. The issue is the law is the law. We've got to follow it, whether we like it or not. And if it's a flagrant violation and it does cause somebody harm, you can bet that the commissioner is not going to be a particularly happy camper, and you may actually have an accusation. And talking to Carlo, who handles the investigation side, that was made pretty clear to Cody and I the other day when we had our conference call in preparation for the panel on Thursday. So that's something you need to be very, very careful about. Then, another interesting call that Cody and I had was with June Barlow, who is the attorney for CAR, puts together a group of nerds like Cody and I, and we get together twice a year. And one of the attorneys is a gentleman by the name of Steve Spouse. Steve specializes in insurance. And he said that the insurance companies are taking the position that if you are accused in the complaint of a flagrant, intentional, semi-intentional act that causes damage, they don't have to cover you. Right? John, you do a lot of insurance work. They don't have to cover you. Why? Because under California law, you don't have to, you can't be covered for intentional bad acts. Now, obviously, that would be litigated in a reservation of rights and something like that. But you've got to be very careful. And then lastly, both Linda and Lori told me that the number one call that Professional Standards is getting is about signs. Okay? There's not a great deal of difference between an open house and a showing. There's some, right? But there's one thing pretty clear. Directional signs are not happening, right? Number two, if you're going to post an open house sign, you're taking some risk because you need to make it clear that even open houses need to be done by appointment only in a very specific manner, defaulting first to virtual showings, which, by the way, from what I can see in the sale of my house, nobody's adhering to. They're all still physical showings. I haven't had one virtual showing unless they went on the MLS. So again, you got to be careful about the signs that you put up and the way that you're documenting your file, because even though, you know, we're still starting to look at some light at the end of the tunnel, when this will all end, who knows? But you know, certainly it's not the same panic mode that people were in March and April that they are today. But still, got to be careful about that. And so right now, signs are the most likely way that Professional Standards is going to be contacting you, and that's true in Orange County as well as in Southwest Riverside County. Okay, so there's that. Couple couple of real quick things just to point out, and then we're going to open it up for questions, because I really wanted to give you guys your shot. And I can hear now, so I don't know how that happened, but somehow my phone is working. Still can't get it on. So I did hear most of your comments, Cody. They were good. Cyber fraud, right? Everything has changed since March, right? You know, you're going Grubhub, you're going Amazon. You know, people don't go to the mall anymore except to, you know, see other human beings. Okay, what we're seeing is both in real estate and in retail is a tremendous uptick in what I'm calling cyber fraud. Apparently, that's not really a word because I had to fix it when I was typing up a letter. But the bottom line is that we're seeing fraud through the internet in ways we've never seen before. I've told some of you, I know Terry, I've mentioned it to you, my son-in-law works at Google, he's a designer there, and it's absolutely unbelievable. Before the pandemic, we were seeing it where someone would try to hack in to an escrow account and have the money diverted to another account. According to the FBI, in the billions of dollars that has occurred. Where money was diverted. I've had about 4 or 5 cases. I know Cody's had a few where that actually happened, and who's liable for that. But the area that's really spiked up in the last couple of months is Craigslist apartment rental fraud, where people will troll your lease listings, and then they will take that, they will put it on Craigslist as if it were their own listing, and they will rent to some poor, unsuspecting tenant, and they will keep the money. The tenant thinks they just rented a nice apartment and find out that they didn't. And of course, in some cases, they were actually able to get in and move in, and now you've got a squatter situation, which, based on a phone call I had with the police last week, is a civil matter, and they're not going to take any action whatsoever. So be careful of cyber fraud. We're going to Cody and I we're changing our locations of work, I guess is the best way to say it, and we're going to be writing some stuff for you guys. But be careful about dealing with your situations on Craigslist. Check your listings every now and then, particularly if it's a rental listing. Put signs up so that it's very clear that they should be coming to you and not to somebody else. And just take care with that. Social media, I just want to touch on that real quickly. 2 things is, obviously people think that because they put it on social media, somehow it's like you can close your eyes and it's okay. One of the areas we're getting some calls on is in the Facebook groups. So be careful about the Facebook groups for 2 reasons. Just because you're in a small group doesn't mean other people can't see what you're saying about them. Right? We had a case not too far back where they were saying some bad things, allegedly. I didn't think they were that bad, but they were saying some allegedly bad things about somebody, and that person got wind of it, and suddenly that person is screaming defamation and all of that. So be careful about what you say. Then the other problem I have is, with all due respect to all of you, I know you're all smart people, but sometimes somebody thinks they know something that really isn't true, right? They think that the rules or the law is written in a certain way, and it's not. And so what ends up happening is you get into this Facebook. So, Pauline tells Sandy, who tells Deborah, who tells Terry, who tells Robin, and the next thing you know, you got 5 people that are operating incorrectly, right? So be careful about the Facebooks. Be careful about what you say on social media. We had a situation about a month ago, I guess it was, Cody, where I have a client. He's got about 400 agents, and he's also a major player at CAR and at NAR, and he made a comment. He was angry. It had to do with some riots that were going on in an area where he lived. He was not happy, and he made a comment. It was not a racial comment, but it was a religious comment. Let's just leave it at that. And he got himself in a whole lot of hurt. So be careful, because if you make a comment on social media and it is real estate related, you've just opened yourself up to a fair housing claim. Okay? So be careful about what you say. I know, a lot of places, emotions are running high. I know the Board of Supervisors is meeting, I believe today, to decide if we're going to open up our county or not. That's not going to affect everybody, but it's going to affect some. A lot of people are thumbing their nose up. So emotions are running high, so you just need to be careful. So with that, Cody, unless you've got anything more, I'm sure you do, I'll listen to you for a few minutes and then we'll open it up to question. And yes, Craigslist is horrible when it comes to that, so just be careful about Craigslist. I saw a comment just now. Go ahead, Cody. What do you got? Anything else you want to add?
Can you hear me, John?
I can hear you.
Okay, good. Well, thank you. I've generally, you covered a lot of the bases with the new laws. I do want to add to the Craigslist portion, though. Really, we are seeing a lot of litigation and liability coming out of some of these things. And from more of a risk management, preventative standpoint, it's so important to just look at these new apps, these new trends, these cash apps, Venmos, things like that, and really take a proactive approach when implementing any of that in your business. Really, I've seen a lot of wire fraud issues lately, issues with Venmo, people sending the wrong perhaps amounts when using them in transactions, or to people who are the wrong party in transactions. Venmo and those apps don't really do anything to help with that. Really, it's between you and the party you sent it to. When things like this come out, I would just encourage everybody to really look at the application, look at the potential new method of implementing it into your business, and determine how it can be misused before determining how you're going to use it. Really, I think that's one really smart way to go, to make sure that you're advising your landlords correctly, advising your agents correctly if you're a broker, and to just really essentially head off some of those complications up front by really understanding what you're doing. Goes towards John saying as well, if you're going to use the form, read it, right? Read the form before you send it out. And similarly, before you implement any new technology, application, understand it and understand how it can be misused against you, your company, or your clients. Really, that's more of a adding on to the Craigslist portion, but I know we have quite a lot of questions on the side that I think I want to get to. John, do you have anything else to add to that?
Mention one thing. I just was looking at my notes. I forgot to mention, and that is, if you're a broker under the fair housing laws, there's a specific provision under Regulation 2725 that says that you must train on fair housing. You must. It's not a you should, or it's something that's a good idea. There's a subsection of 2725, which is the broker supervision regulation, that says you must make your agents aware. So if one of your agents is caught allegedly violating a fair housing rule, there's a very good possibility that you're going to be named simply because you had a duty to supervise that activity. And if it's established you did no training or don't have a written policy, you need to be very careful. And I just think all of us, including lawyers and John, Glenn, who have their own practices, myself, we all need to rethink our policies. I know that I had a case last week. I just got to tell you about it because it was so unusual. 2 weeks ago, excuse me. My client calls me. He's a very large brokerage up in the Orange County, Long Beach area, and he says, "Hey, I got an agent that's posting lewd and suggestive photos of himself on Instagram." Well, I don't use Instagram, so I really don't know what that all means, except I do know what lewd and suggestive means, and he told me. Well, the problem was I called Brandon because that's, frankly, I've never had that before, because here's the issue. It's certainly, the broker was getting calls saying, "What the heck is going on over there? You guys are a top-notch firm, and is this okay with you?" And the broker didn't know what to do, right? He did not know what to do, because if he takes an action, then he could be accused of violating that person's rights. If that person is a member of a protected category, in this case, the person happened to be gay, right? But what if he creates a gay rule? Well, that's going to be inappropriate. He's got to create a rule in his social media policy that says this is true for everybody, right? This isn't about women. This isn't about men, about gay, about religion. Simply saying that you will do certain things. We did that. We were fine. But again, it's the kind of stuff you're seeing nowadays because it seems like all bets are off. So let's look at the questions. Okay, well, there's a bunch of questions. Where do you report the fraud to the district attorney's office? Yeah, there's a Riverside. I think Gene Wunderlich is actually a member. Your GAD, and I imagine Adam may also be involved. I don't know, but there is a department inside the Riverside District Attorney's Office specifically that deals with real estate fraud, and they do a pretty good job. Actually, it started because of the Southwest Riverside County Association of Realtors many years ago when we had a group called Stonewood who were out there doing very naughty things, and they're all in prison now enjoying a free vacation. But that's because of you guys reporting that kind of conduct, so it is important. John, I want to be clear. The owner wants to sell the home and is exempt for SB 14, I don't know why. Based on COVID new laws, seller cannot give a move-out notice to their tenant until they are under contract. That is generally true, right? If it's a month-to-month. If it's a term that is expired, let's say it's a one-year contract, there are other provisions that you can try and look to, but you need to really have your attorney take a look at that and make sure you're complying with that provision of law. But generally speaking, most leases are month to month. And if it's a month to month, until you go under contract and the buyer has indicated that they intend to occupy, you're probably going to be out of luck. So somebody asked a great question a minute ago. I don't see it here. Cody, can you scroll down a little bit, because there's a bunch of other questions that aren't on my screen anymore. But basically, the question was, so should our escrows be a little bit longer? Yeah. You'd have to calculate, right? 45 days isn't going to cut it if you got a tenant in the property. Because if you're going to have to give that tenant a 60-day notice to vacate, well, you're already going to be messed up. So, and the contract is very clear that the seller is going to be the one that's going to be open to damages in the event that they do that. So, John, what about UD that started prior to 3/1 for rents due beforehand? That does not fit within the new statute. The only rents that are covered by this particular statute are rents that will come due or have come due from March 1st, 2020 to January 31st of 2021. And there's two different rules. Remember I told you for August 31st, it's all the rent. After September 1st, they're required to pay 25%. But otherwise, as far as I can tell, and I've read this bill a couple of times, and I've read a bunch of stuff from NAR and CAR, not NAR, CAR, and from other law firms, and I've talked to other lawyers. How do I say this nicely? It is a not particularly well-crafted piece of legislation. Basically what happened is the Chief Justice of the Supreme Court put a stay on all unlawful detainers, and sometime in August pretty much said to the legislature, because she'd extended that stay for a couple of times, she said to the legislature, you guys have had 6 months to figure this out. And I can tell you, they were working on various bills until about 3 days before this bill was actually signed. It went to the governor, and he signed it within moments. So a lot of people haven't really read this bill. And it's got a lot of, I don't know, Cody, if you agree, you can shake your head for me, but you can tell everybody what you think. But when I look at this bill, there's just a lot of ambiguities. There's going to be a lot of what ifs. It's good for John and Glenn and Cody and I, because people like us are going to get called to try and interpret this stuff. But it's really and this is my personal opinion. It is not Terry's opinion as your president, or Connie's as your CEO, or any other director, Pauline, any other director. my personal opinion, this is a sloppy piece of legislation that, while I understand the public policy because of the concern about homelessness, a lot of people would have been booted out on the street that would not have been able to get another property. So from that standpoint, I can understand, but they waited until the last minute. They had 4 bills that were pending, and some of them would have required you to wait 15 months to collect rent. Some of them would have provided tax credits, which were totally unworkable. This ended up being the compromise piece of legislation that was pushed through at the last minute and signed by the governor. And it's going to probably, a couple of things about it also. I believe, and I could be wrong, I'm just guessing, that a lot of the deadlines, particularly the one in for next year that says that they can start getting unlawful detainers filed, if they start seeing an uptick in any of the homeless issues or anything like that, you can venture a pretty good guess that they'll extend those extensions. The bill on its face expires in February of 2025. Oh, the other thing is, I forget the term, where you guys can go to a particular site and you can find out, tenants that have been nice and tenants that have been naughty. I forget what it's called. There's a term. It starts with an S. I just can't remember. But the bottom line is that this bill blocks your ability to report tenants who didn't pay rent because of COVID-related issues. You're not going to be able to do that. So you can't go onto a site, find out that a tenant blew off $20,000 of rent. You're not going to be able to do that. So that's not going to be something available to you.
John, if I can add to that just very briefly.
Go ahead.
You did note that there is some poorly drafted language in the law. I think that really just when you're looking through online, I would just caution you guys to run it through a few different sources. I've seen in 10 different articles, 10 different variations with different timelines, different types of notices, some say you need statutory language, which you do. Others don't reference statutory language at all. I would just really recommend if you guys are looking for guidance on 3088 to see an attorney, or to go and at least compare multiple sources. SRCAR's is pretty spot on for their articles on this, but if you're Googling things online, you will find different interpretations of this. So I just want to make sure you guys are aware of that when you're looking around and not necessarily relying on one source.
As far as, better fix this before Thursday. As far as sources of information, Cody points out a really good point. I would start at SRCAR. SRCAR has a really good Q&A. It's about 25 pages long. It's laid out, from A to Z. Make sure you use the one that's dated September 14th. There's 2. One is dated September 1st. One is dated September 14th. The one that's dated September 14th was revised, obviously, for some rethinking of some issues because they were, I won't say clearly wrong, but questionable on some of the judgments that they made, but the one on September 14th, in my view, is very, very good. Next week, the forms will be out. You should read all those forms. Now, we're going to do some of that for you, but I don't know how many of you actually read what we write. If you read it, and Connie does the best she can, she puts it on the website. What's that old adage? You can take a horse to water, you can't make it drink. So drink, In fact, after all this is said and done, I think we could all use a drink. I'm not sure. But take a look at the forms and then really analyze these things on a case by case. All right, I'm open to any questions whatsoever. Cody, if you've got one this one is just, I may be dense. Well, that's 2 of us. We have a tenant who's behind 2+ months in rent. Property owner wants to sell the home. Tenant does not respond to email, text, or calls very often, so showing the property with him in the home will be next to impossible. Is there anything special we need to do to protect with COVID? Otherwise, we just give notices. No, okay. That's a lot of questions. First question is, if he's 2 months behind, then and you want to ever collect the rent in small claims, if it's from March to to now send them the notices. As far as showing the property, we've had this question since day one, and it depends on who you talk to. If you talk to the Department of Fair Housing, they'll tell you you can't have access. If I'm a tenant and I say you cannot come in because I'm afraid of COVID, even if that's not true, then you probably can't get access. However, Cody and I were talking this morning, and John, this is something that you and Glenn can chime in on. There may be a question of fact. If you can establish, for example, that the tenant, it is a violation of the lease. It is a violation of law, right? But then we don't know what judges are going to do if I say, I'm not letting him in because I'm afraid of COVID. But then that tenant, if you can establish, has been going out to dinner, has been going to work, has been doing all this other stuff, and you are willing to comply with the PEADs and with all the other stuff, you may have a claim. I don't know. I've not personally had that situation come up yet, but then I'm not a litigator. Otherwise, you just keep in mind that you need to follow all of the basic rules. It's going to be tough with a tenant in the property that doesn't want to comply. Now, according to statistics, that's not a big. That's about 10% of tenants. I don't know. Maybe you guys are. Maybe it's worse out here. I don't know. But according to the statistics, we're not seeing all tenants do that. It's really a relatively small group. But if you're lucky enough to have one of those tenants, you probably have some problems with access. John, you are stating that the forms don't come out until next week, but we only have, okay, great question, Michelle. I didn't make it clear. The form that you need to send by September 30th is available. The NRTA is available right now. Go to your Zippy forms or whatever you guys are doing now, and that form is available. It's not much to fill out. It's got all the information, and just send it to all your tenants that owe rent between March and August 31st. Okay? All the other forms, there's 3 or 4 forms that are available now. All the others will be due next week. So, in giving notices to pay rent or quit and 15 days and all that. The declaration is on the DRE website, and I believe the declaration is also on the CAR website. I would use the CAR because their declaration has more cool stuff in it. Okay, more information that I think would be valuable. Whereas the DRE's website just has the declaration, so I would use that. But I apologize if I didn't make that clear. The form that you have to send out by September 30th is available now. If you don't send the form for some reason, and frankly a lot of it's going to be because people simply don't know they need to do it, right? Then you're still going to be able to send the form out after October 1st, but you're now going to be burdened with the task of doing that first before you can send out any other notice. Okay, right now, if you send out that form, then the whole package can go out whenever you decide to do it. But so that's why it's important. And frankly, since you're here, you've taken the time, you know now to do it, just take a list of your tenants and just send it out. You can mail it. You don't have to personally serve it, if I recall correctly. If your lease allows for email delivery, you can email it, but don't play games. Get it to them. If you have a good relationship with your tenant or tenants, and you don't have 5,000 doors that you're managing, then have a little personal interaction, because frankly, personal interaction is going to be critical down the line as you try to work out how you're going to get repaid. I just think today, and we've been saying this in the property management field for a long time, there really needs to be respect. And I know that there's going to be tenants that are going to be, I don't know what the word, jerks, I guess, for want of a better term. But the reality is that they're holding most of the cards, right? They've got possession of the property. They're not paying the rent, and you're going to have to use some good business decisions, good business judgment to try and work things out with them from a financial perspective. Is there a new form that will address tenant-occupied property and removal of the tenant during escrow? Yes. There will be forms if you follow the law. I mean, I don't know how else to say it. The forms will be available to you, and it's no different than the process now, except it's been expanded. And so you're not kicking the tenant out because they didn't pay rent. Stay away from that. Stay away from that. Remember what the law says. If the eviction is in whole or in part due to unpaid rent, you're dead in the water. So the reason for kicking the tenant out is you're in contract and the buyer intends to occupy. Period, end of story. And then work your escrow around those dates. And of course, you can always work out certain kinds of, concessions. I won't bring a small claims case against you. Right? This is not you, this is your client. I'll waive my small claims claim against you if you will leave by a certain date. And there is going to be a form for that. Okay? So you can do those kinds of things. People, according to statistics, people hire realtors because of your negotiating skills. Well, it's pretty important that you use those skills now as best as you can. Those of you that are brusque, that are rude, you're not going to do too good, I don't think. Because if you threaten people and you're caught, you're looking at fines up to $2,000 a day. Okay? Maybe even a DRE complaint. So for those of you that are good negotiators, skillful people, I guess for want of a better term, you're going to do better. You're going to be able to sit down with these people as human beings and try to work it out. Most people really are in a bad way. Let's face it, the people that we're talking about are the people that were in the service industries that were, laid off, that were, where their restaurants were closed. 90% of restaurants probably aren't coming back. Sizzler just declared bankruptcy, right? So you're looking at a really bad situation here. And who knows when it's going to end. Okay, let's see here, any other questions? I don't know, Cody, do you have any other questions? Like I said, I can only see so many of them.
I've been answering quite a few on the side, given the fact that you couldn't hear for a majority of this. Let me just double check. I'm going to go to the top.
And also, by the way, while he's doing that, if you want to unmute yourself, make a comment or ask a question, I'm open to it. I mean, I can't wait till Connie opens us back up again. I'm so, the nice news is I haven't worn long pants in 5 months, and I don't even know. I got to undust all my suits, but I've so missed the live interaction. But the nice thing is we have 100 more people here today than we would have been able to have had we had gone live. So that's kind of cool. But I open, I can't see your hands. So if you've got a question on any subject relating to anything, frankly, we'll make up a good answer if we don't know.
Wendy had a really very good question.
3 other lawyers on the call today, so one of us will come up with a good answer. So anybody got their hand up, Wendy?
Wendy had a question for open houses.
Hey, Michelle, you have another question. Cody, did you have something?
Yes, Wendy had a question for open houses. Wendy, do you want to unmute yourself, or if not, I
can. Hey, John. Hey, everybody.
So Wendy, then Michelle.
I just had a question regarding basically what is the legal stance on open houses, and how do I navigate that when I'm instructing my agents not to do open houses based on open houses that they're seeing? What is the actual legal precedence behind no open houses from CAR right now? I guess that's kind of the question.
It's nice to see you. I haven't seen you in 6 months. Wendy's one of my best buds.
Miss you too.
Number one, this isn't CAR. I want you to understand that. CAR, all they've done, excuse me, this is really annoying. All they've done is taken what OSHA and the rest of the state did and put them onto forms the best they can. Okay? Neil, Howard, Gov, all those guys have worked their tails off to do the job for you guys. Okay? Take a look at the best practices, the BPPs. Okay? Adopt those and then follow them. As far as open houses are concerned, they kind of lifted. There was an absolute ban on open houses for a while, as you know. Now it says, number one, they are to be virtual wherever possible. Number two, they are to be done in a manner that limits the people that are in the house to, and depends on the jurisdiction. Generally, it's 2 plus the agent, okay? In Long Beach, it's 1 plus the agent, okay? It has to be the buyer, not, I know that, and somebody violated it here the other day in my house. They came with their parents, right, who weren't buying the house, but were probably going to write the checks, hopefully pretty soon. But there's that. Then you need to still follow all those other rules about making sure that someone is responsible for providing masks, that someone is responsible for making the place clean after each showing. You want to space, whether it's a showing or an open house, to and I'm not sure, other than the fact that in a showing they're supposed to be already pre-qualified. You still need the PE8D forms, which Glide, from what Ed Zorn told me, most people are doing through Glide. I think he said there's already been over 200,000 Glide PEDs, at least through MLS. So that's how you do it.
John, the glides will apply.
Hold on, wait, I got it. Turn you back up again.
Sorry.
Okay, go ahead.
The glide will apply to an agent showing, but not to an open house showing necessarily.
Okay.
Because I guess I'm just trying to get practical on. So what you're saying, first of all, is that Cal OSHA is the one who's brought the guidelines for how we show houses, and what's being adopted when it comes to what agents are doing for practice on open houses themselves. Where are the numbers? Like you had said, in some areas it's 1 person showing and then it's 2 people showing. Where is that information on those guidelines on
I've always whined at you guys that you should stay inside your geographic area of expertise. We don't have any of that here in this area. Everybody is pretty much following state mandates. And I negotiated a deal with the Long Beach city attorney because they wanted to ban all showings except for virtual. We were able to negotiate something a little bit more than that, but a little bit less than what the state's allowing. That's now expired. We're good to go there. So it just depends. But as far as, number one, I would recommend go to Connie and buy one of those signs that say virtual showing available. By appointment only. Warn your sellers that that's what you've done. I know that when we had the coming soon sign out, people were still coming by, right? I mean, people just do what they do, right? But according to the statute, you are ultimately responsible, which I think is nonsense, frankly, but that's the law. But otherwise, Cody, I'm not aware, there's really not too much difference between a showing and an open house, frankly, because what are you doing? You're showing it to a prospective purchaser. Whereas an open house in the traditional sense, you got the balloons, you got the directional signs, you got all that kind of stuff, and you're not doing that now.
Well, I think the big difference would be whether it's an appointment. Open houses typically don't have appointments beforehand. You're just allowing people to walk in. Whereas my understanding is a showing must be by appointment. So that.
And so must an open house under today's rules.
Okay.
The bottom line, just know that hey, Cody, I'll buy you dinner if you come over to fix this. Cody's a technical whiz. As most of you know, I handwrite out my PowerPoints. You just got to me, I don't see a real great deal of difference. There is some minor distinction. It has to do primarily with pre-approvals and serious buyers and all that. But in practice, I've not seen the distinction. The bottom line, have masks, have sanitizer, make sure the seller understands if they're going to take the responsibility, figure out how to document your file in that respect. When I talked to the commissioner about that, he wasn't overly concerned about those technical little, what he was concerned about was where we saw in the MLS, and I swear on my grandchildren this is true, Cody, you were there. I'm not going to follow the rules, come whenever you want, or something like that in agent remarks. And I thought, God, I wish everybody was like that guy, because I would love to take an around the world cruise and people like that pay for that kind of stuff, right? It's the flagrant stuff really that they're concentrating on, because, and again, John Messina up there is more qualified than I am, but in that area where there's going to be an issue of, how did I get sick? Well, you went to Wendy Whitelaw's open house, and that's where you got sick, because she didn't follow the rules. I think that's going to be an enormous burden to have to prove. I just think that's going to be very difficult, particularly since the governor has signed the new workers' comp law that says, if I got sick and I make a workers' comp claim, it's presumed that I got sick on the job. How are you going to prove both, right? Well, I presume I got sick on the job, I made a workers' comp claim, but now I'm suing Wendy Whitelaw because I got sick at her open house, right? I think those are going to be, I think really the bottom line is do your best. Read the BPPP, adopt it and follow it as best as you can. For those of you that have agents, train on it, try to develop some level of consistency, and that's all you're going to be able to do. People are going to make mistakes. Any other questions? Are you going to leave us when your house sells? No. I'm moving to Tennessee for 2 reasons. 3, my wife is from there, and I promised her 43 years ago we would take her home one of these days, okay? Number 2, I don't know how else to say it, this is not Terry or SRCAR or any of my directors. I can't stand what's going on in this state anymore in terms of what Sacramento's doing to the business community. And so, and then thirdly, and I know this sounds terribly selfish, but there is no state income tax in Tennessee. Or any other kind of tax, and it is frankly gorgeous. 1 out of 5 closings in Tennessee right now in the Franklin area, which is where I'm moving, suburb of Nashville, are to Californians. So I don't know who's going to be the last one out, turn off the lights when you come and visit, but no, I'm going to still work quite a bit. We're going to keep a place here, and I'll be traveling back and forth. My son still lives here, my family, my friends, and I'm not ready to retire, so Connie told me that she'll tell me when I can retire, and that's, and frankly, when I do, I'm hoping that you know, that there'll be somebody. I know Cody is, you know, as far as I'm concerned, the right person, but we'll see. You know, I'm not ready to be kicked out to pasture, but that's selfish. Okay, some agents are stating pre-approval of prospective buyer must be sent to the listing agent before the showing appointment will be made. Is it legal to demand this prior to setting a showing appointment? Yeah. Now, obviously, you need to go through all this with your seller, right? We've always talked to you guys about you need to be a counselor, right? It says on my card, I don't know if it still does, but it used to say attorney and counselor at law, right? That's what we are. We counsel people. You need to sit down with your sellers. The new coronavirus listing addendum has everything in there you need to talk to them about. The seller's PAD has all the other stuff, and go over that stuff with them. What do they want to do? Obviously, at the beginning, where things were, you know, where people were a little more panicky about the illness and things like that, things were a little bit different than they are now, but maybe not that much. And of course, with the market being what it is, but it's absolutely not a violation of the Code of Ethics, the MLS rules, or anything else to put in your remarks that the seller must be provided with whatever the seller has told you they want, and the PADV form that is absolutely mandatory. Okay, you're allowed to do that. So that's a great question. What is the median income for Riverside County that we need to use? I don't know. If you go to the CAR site, there's a link. You can go there. I suspect it's probably lower than the $100,000 threshold, so you're going to have to do some math. Remember, the person has to make 130% of that number. but at least 100,000 a year, as I understand the way the rule is written. Okay, must have a going away party for you. Thanks, Wen. Love to, but I'm not going away. I'm like that rash that just comes back periodic. I'll still be around. I still intend to work on the courtside newsletter. We still intend to hopefully have classes and programs, and I can't wait. Next year we have a brand new RPA, 16 pages. Can't wait. Gonna be doing that with Barbara Horan, I believe, next year. What is the stand on agents requesting the buyer to pre-qual approval? Well, we just answered that. Oh, with their preferred lender. Great question. Perfectly appropriate. If your seller has said okay, right, you can require that the buyer pre-qualify with the lender of your choice, because that's all that they're doing is pre-qualifying. You cannot, under RESPA, require that they utilize that lender. And I think I told you guys, for those of you that were there at one of the brown bags, that we had a case where the DRE actually opened up an investigation because the agent did exactly that. He was requiring, because of the low inventory, that the prospective purchasers pre-qualify with his mortgage person who he had a very high level of confidence in. It was reported to the Department of Real Estate, and what they wanted proof of was two things. Number one, that there was no financial incentive being offered to that agent to send prospective clients to that mortgage broker. If you're getting anything of value, you might have a problem if you're reported to the Department of Real Estate. And then secondly, that there was no requirement that person be utilized in the transaction. Now, when I talked to the broker, the mortgage broker, she told me that she was, getting about a third of those calls. So there is an incentive to do that, obviously, but she wasn't doing it inappropriately, and the DRE closed their file. So vendors repair or rentals outside versus need a PEAD. You betcha. Okay. Here's the deal with the PEAD. All visitors, technically, under the rules, are required to send you a PEAD, and most of the good agents that I'm talking to do it before they even show up. Okay. Now, we got a call early on. I don't remember who took the call. I think it was me, Cody. I don't remember, but we took a call because the inspectors up in Orange County were refusing to sign the form. But here's what was happening. They were getting the form when they showed up for the inspection. Well, most people aren't going to sign a two-page, single-space legal document, without reading it or having somebody talk about it. So we went to the organization. I talked to their president, and we agreed that what you should do is send the form to whoever you're going to ask to come into the property ahead of time. Ask them to review it and then send it back to you, and then you're good to go. But technically speaking, everyone that goes into the property is supposed to sign a PEAD. That's that's on the buyer's side. Where we also saw some issues come up. I don't know if it's still happening, and again, I don't sell real estate. I'm just a simple country lawyer. But where the sellers were not allowing buyers, agents, and not agents, but vendors and repair people and that kind of stuff to come in, and that was technically a violation of contract. What we haven't seen yet are any lawsuits that are going to talk about things like force majeure and impossibility of performance and all that. 16-page contract. Wow, I'm moving to Tennessee. Their contract isn't any smaller. Okay. Here's the deal. The current contract doesn't have a lot of cool stuff in it that it should. Okay. A lot of the 16 pages is, and again, they were going to come out with it this December. They thought, you guys just had too much stuff on your plate. They didn't want to see realtor heads exploding all over the state, because now, aside from everything else, they've got to deal with a brand new contract. Okay? So what they did is they completely revised the contract. The first, I haven't looked at it in a while, when they told us it wasn't being done until next year. The first 4 or 5 pages really, you know that form where you can summarize the offer and send it over to your client? It's that kind of stuff, right? So really it's the first 3 to 5 pages of the form that are going to be the most significant. Then they put all the so-called boilerplate stuff to the rear. Then they did things like, instead of having the mediation and arbitration clause in the same paragraph, they're splitting them up now, because people were getting confused. Well, if I didn't initial the arbitration clause, that means I don't have to do mediation. That was never the case, so they've done that. I just think it's a much improved form, personally. And come on, 16 pages, you know. We're meeting tomorrow to go over the sale of a real estate brokerage, and the basic contract's going to be over 40. I mean, come on. Let's face it, contracts are long, and this one's a good one. I really think once you see it, you're going to be happy. But come to Tennessee anyway. I've got a really great realtor I can introduce you to. She's the president of her board, and she's 32 years old, and she's absolutely brilliant. Happy to introduce you. But that's that. From SRCAR, you guys are having movie night, $25 per car. That include vans, Connie? I'm moving to Franklin, if anybody, there's a question there. What if we send the PAD ahead of time and they signed it ahead of time? You got to do it at or about the time they're coming. This is a question from Michelle. You got to do it pretty close to the day, because technically speaking, you could get sick the next day, right? So you want to kind of make it arranged so that, you know, the PAD form is signed each and every time. And yes, a new PAD needs to, I know a lot of people are pre-dating and post-dating and all that, and probably not appropriate, because if somebody gets sick and you played those games, you could get yourself in a lot of trouble. But go to movie night, because that sounds like fun. Is it a good movie? Oh, while she's doing that, somebody reminded me of something.
John, it's at the Storm Stadium, and it's the night at the museum. I attached the flyer, so I'm giving a cheesy shout out. So if any of you guys want to go, please, tickets are on sale until tomorrow. And you can see us face to face, because we're all going to be there.
All right. Somebody asked me what the 6 questions were, and I'll be darned if I didn't forget to tell you. So, I can't find the document, but I'm going to tell you what they were, because I remember since I wrote them, what most of them are. Here they are. I did find it. I lied. So, first question. Does the Department of Real Estate intend to sanction a member who fails to follow the OSHA and other rules for showings, open houses, or who fails to obtain a proper PEAD type of declaration, and under what manner? We've kind of already talked about that. He indicated that if it was non-intentional, it would probably be a warning, maybe a cease and desist type letter, maybe a citation, which, as you know, can go up to $2,500, but probably would be less. He thought, you know, something where it was more, again, it's going to be what was your sort of intent. But if it's flagrant, basically the word he used is, what is the level of disobedience? Okay? That's a very subjective analysis, isn't it? Okay? Number 2, has the DRE processed any COVID-type claims, either by citation or accusation? Yes. At the LA office alone, there are 43 COVID-related landlord-tenant cases where the landlord failed to follow the law and allegedly intimidated tenants. Now, these are all licensees, so these aren't necessarily landlords, probably property managers, but 43 cases in one office on one guy's desk. Now, he is the chief. a lot of cases. So yeah, they are attacking these issues, and once the investigation is complete, then the way the process works is they usually will then turn it over to one of the prosecutors for an accusation, and at the point in time where the accusation is issued, then it becomes public record, and once it becomes public record, it goes on your background. And if I check Wendy and she's got an accusation pending, it's going to be there even if she settles the case. It's never going to go away, and there's procedures for that. What are the DRE's primary broker supervision concerns during the pandemic? Number one, sorry, I gotta turn this on. Number one was discrimination claims. They want you guys to be, whoever's a broker out there, they want you guys to be teaching the discrimination laws. They want you to do that. So that was number one, is our broker. Remember, this just came on the heels of this whole Long Island thing. Obviously, all you got to do is open up your TV every night and you're seeing the unrest that's going on around the nation, all that kind of stuff. I mean, it's hard to ignore what's going on today with all the different issues. And so number one was discrimination. Number two was agent fraud. And so, again, they're always concerned about agents who are taking advantage of clients for their own financial benefit. And there are specific provisions in the law that govern all of that, and they're very, very sensitive about that. And then lastly, his primary concern, and actually he said is just overall training. We asked him, why do you think they passed a law that requires brokers to undergo broker supervision classes as part of their renewal? And he said because brokers don't train. They're not supervising the way they should. And his particular concern were teams. So if you're a member of a team, you're on his radar, because the teams act like little mini brokerages, sometimes not even mini, but they act like brokerages, and they're not. And so when we talked to him, that was something that he was very clear on. If the broker learns that their agents are violating discrimination or fair housing or Department of Fair Housing rules, what should they do? Terminate and report. And that was a very long conversation we don't have today, but the essence is, first you sit down with your client, then you talk, first you sit down with your agent, then you talk to the client, you make some determination if it was an inadvertent sort of one of those biases that we may have that isn't necessarily blatant, and then you get the training and you start instituting. But if it's something blatant, it's conceivable that you have to terminate that person and report it to the Department of Real Estate. I would urge you guys all, at the minimum, there is a fair housing advisory that SRCAR has. It's pretty good. I actually quoted some of it today. You can go to the quick guides and just type in the search and you'll find it. And then last question, are there suggested additional documentation steps and or things that brokers should be doing in addition to the COVID declaration? And we just got into a very lengthy discussion about proper ways of documenting your file, use of language, things you put in your file, how do I say this nicely, that are stupid, right? Calling people names, using certain kinds of words that shouldn't be in a professional file. Basically, and I don't know how others would advise their clients, but I've always told you guys, put stuff in your file like you're writing to a jury, because you may very well be writing to a jury, because that first thing that plaintiff's lawyer is going to subpoena is your transaction file. Don't destroy any evidence. So we talked about a lot of that, and then the last thing we talked about were the love letters, and he also has some concerns. A quick tip: it's okay to ask for identification if you're making sure that someone who's coming onto the property is who they say they are. I mean, that's appropriate, but you better do it for everybody, or you better do it exactly the same. Because if I ask for for identification from a person of color, and I don't ask for identification from Wendy, then what have I just done? Right? So be careful about that. Be careful about the letters. Make it clear with your seller how you want to handle those letters, and then deal with that. I know that my daughter just sold her house. She's moving to Tennessee too. One of the main motivators is my 3 little grandsons are coming with us. She bought 18 acres. She sold her house in 2 days with 14 written offers. Okay, Orange County, different. And she got a lot of letters, and so we talked about that because she, gets free legal advice, and so we were very, very careful about some of those letters. And one of the letters actually did sway her, but it had nothing to do with anything that was inappropriate. But again, you got to be careful. And that's the last thing we talked to him about. And it is noon, and I promised you guys I would give you your lives back at noon. And so, unless there's any other questions, anybody raising their hand that I can't see, I'm going to say keep your eyes peeled. Next week come the forms. We're going to go through them. We're going to continue to do courtside. We'll keep you posted on our whereabouts and all that kind of stuff. But otherwise, it's tough out there. If you're a property manager, quit. Get out of it. I'm kidding.
John, can you
Between
answer
the housing
Deborah's
issues
question
and
really quickly?
the COVID-19 and making sure your trust stays in balance, got a lot going on in property management. NAR said it's now the #2 reason you're going to get sued. So just be careful. I'm not telling you not to do it. I know it's very lucrative. Most of you do a bang-up job. Your services are certainly necessary. By the way, the #1 way you're going to get sued is if you're a dual agent. Right? Okay, and with that, unless there's any other comments, I'm going to leave this meeting. Connie, you got anything else you want to say to these lovely people?
No, thank you. Can you hear me? You can. Yes?
What's that?
Okay, thanks. No, thank you very much, John and Cody. Very informative information, but at the same time, incredibly scary. Don't forget about the movie night. I hope you guys are all come. I can't wait to see your beautiful faces. I can't wait for the world to open up. And remember, the association is open all week in different locations. So if you need us, we're here for you. Thank you.
Okay.
Okay.
Thank you, John. Great brown bag.
Thank you, guys. Thanks for coming today.
Thank you, John.
Thank you.